The first matter to come before us this morning is State of Ohio versus Arthur McCall. Each side will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. I'm keeping clock this morning, so if you'd like to reserve that time and let me know ahead of time, I'll try to keep you apprised. We've read the briefs and we're ready to proceed when you are.
Good morning, Your Honors. Mariette Solanska on behalf of Appellant, the State of Ohio. I would like to reserve 4 minutes. The state has assigned 4 errors to a decision of the trial court to suppress the results of a blood draw in an OVI case. In this case, factually, the background is that police officers got a tip about a car sitting on the highway or sitting on the roadway not moving. They go, they find the defendant behind the wheel, they eventually arrest him, they've got all the smell of alcohol. Those things are not at issue. What happens is they take him back to the police station and they advise him pursuant to RC 4511191A5B, which is Ohio's implied consent statute, that under that statute, the defendant is required, because he has 6 or more OVIs in the past 20 years, to submit to a blood draw. And what happens basically is, first the defendant says, or not a blood draw, I'm sorry, let me correct that, to a test. The defendant says, okay, I'll give a urine sample. They take him into the bathroom and he says, no, I'm not going to give a urine sample. And the officer says, well, then the other option is for you to take a blood test. And this is again based on the implied consent statute, which states that a defendant can be compelled to give a blood sample or a urine sample if he meets the statutory preconditions of having, I think it's 6 or more OVIs within the past 20 years. Mr. McCall then says, well, I'll take the blood sample. He's taken to the EMH hospital and he submits to a blood draw, and everything is done without incident. And then the case gets bound over from Elyria Municipal Court after Mr. McCall is charged with OVI. And on April 11th of 2013, it was bound over on March 7th of 2013. April 11th, the grand jury indicted Mr. McCall for the felony OVI based on, in the state's evidence, which of course include the blood sample that was taken from Mr. McCall pursuant to the implied consent statute. At that point, a motion to suppress is filed with the trial court, and the state assigns 3 errors because the trial court ultimately granted the motion to suppress evidence and held that the state could not use the blood evidence that was withdrawn. The court first focused on Missouri versus McNeely, which is a Supreme Court case that actually was, the decision of the U.S. Supreme Court was announced on April 17th of 2013. That was about 13 days before the court decided this motion, which was on April 30th of 2013. I may be misspeaking, it may be later than that, it may be 214, but I didn't remember, I didn't write it down exactly, but it was clearly, right, this case was pending when McNeely was decided by the U.S. Supreme Court. The state alleges that the trial court incorrectly applied McNeely to this case because, first, in McNeely, what the court held was that the natural metabolization of alcohol in one's bloodstream does not per se create an exigent circumstance to justify an exception to the warrant requirement. What's important to note, and in Delaware versus Freddie Flannery, the Delaware Supreme Court analyzed McNeely in this matter. They said that it didn't apply because in McNeely, the court never addressed an implied consent statute, although Missouri had one at the time. I'm not sure what the exact language of the statute was. The court simply went on a Fourth Amendment basis and said, you have to prove exigent circumstances beyond just the dissipation of the alcohol in the blood. The state submits that McNeely doesn't apply in this case because Ohio has an implied consent statute. And I think it's important to note that even in McNeely itself, the U.S. Supreme Court noted that implied consent statutes are among the broad range of legal tools that states have to enforce their drunk driving laws to secure BAC evidence without undertaking non-consensual blood draws. And the state submits that even there they recognize that the states have the right, and Ohio has recognized that they have the right under their own sovereign immunity to decide to create statutes. And that statute was not held unconstitutional. And the state would submit that essentially that's what the trial court did here. They said that Ohio's implied consent statute, well, they didn't say this directly, but by saying that under McNeely, the implied consent statute goes out the window, he's saying it's unconstitutional, and that's 4511-191A5B. In this case, the state believes that the trial court was wrong because, for several reasons, but I think the main reason is that it really is inapplicable because they don't address it. The second reason that I think it doesn't apply is that the purpose of the exclusionary rule is to deter future misconduct by the police. In this case, the police didn't do anything. They relied on a statute that was constitutional at the time. There was no decision from the Supreme Court that said, that might have even arguably called that statute into question. And they relied on that and applied it. So what misconduct are we deterring if the court is able to grant the ultimate remedy for Fourth Amendment violation to say, we're going to exclude your evidence completely? In this case, I don't think that that's the appropriate result. And there are many cases, and I think that I've cited in my brief, and in which we indicate that it doesn't apply retroactively, that McNeely should not be applied to exclude evidence that the police took in good faith reliance on a statute that was constitutional and on case law from this court that said that statute is constitutional.
Well, there are cases, you're focusing on the fact that at the time the sample was, that the decision was made by the trial court that, let me back up.
If I may clarify.
Yes, go ahead.
What the state is arguing is that when Mr. McNeely was arrested and submitted to the blood sample, McNeely had not yet been decided. So the police were relying on a statute that was constitutional at the time, that this court had held constitutional, and then shortly after Mr. McNeely is indicted, he files a motion to suppress on the basis that this McNeely case, which came out after Mr. McCall's arrest, was applied retroactively and meant that the state's evidence had to be suppressed. And that's what the trial court agreed with. They basically said, we're going to suppress it on the basis that under McNeely, the state didn't prove any exigent circumstances beyond that per se dissipation of alcohol in the blood.
But Applee is citing cases that stand for the proposition that cases that are pending at the time of the pronouncement of the U.S. Supreme Court are governed by that, and this case was pending at that time.
I think that's, there are cases that do say that, and especially you think of we've had some issues that have come up with the juvenile sentencing laws with respect to the U.S. Supreme Court case that was decided and what would happen there. And that, and I certainly have even argued that myself, but when you look at what the purpose of the exclusionary rule, which is the analysis that the U.S. Supreme Court used in McNeely, is to exclude evidence that's obtained by the police where they violate a defendant's right. And what the state is arguing is, at the time, there's a good faith exception to the warrant requirement. It's a well-established exception. And the police were relying on good faith on a statute that said, this is what you do in Ohio. If a defendant says, I don't want to submit, you read him the language from the 2255, which I've quoted in my brief, which states that they can force him to provide a sample. They can use whatever means reasonably necessary, is the language in the statute. And in this case, it wasn't as if Mr. McCall was held down or anything else. He was offered the opportunity for a urine test. He initially agreed to it, then he said, no, I'm not going to do it. They said, well, then the other option, based on that statute, is you do a blood test. And he said, okay, I'll do it. And then without incident, he was taken and the blood sample was drawn.
What are we to do with the fact that the court's interest is that based on these grounds alone, the failure to substantially comply with the testing procedures, that they're suppressing the results?
That's the state's third assignment of error. In that case, Your Honor, I would submit that what what occurred was, it was never in the initial motion to suppress, that the state had not complied with certain, there was not a factual basis to say that the state hadn't complied with the two provisions of the administrative code, that the court ultimately said that that basis alone was sufficient to suppress the evidence. And in this case, the state objected that there was not a sufficiently particularized statement of facts to support any argument for that.
The appellee quotes the section of what I think is coming from the appellee's motion to suppress about the blood sample not taken in compliance with the testing procedures. So what's not specific enough about that?
Well, it's that they don't argue facts that are specific. They say the state didn't comply with the OAC, but they don't say these are the reasons we're arguing that the state didn't comply with the OAC. And the prosecutor objected to that. And the trial court himself noted that the motion was conclusory in nature and didn't refer to any particular facts. And this is the transcript at pages 3 and 4. It didn't refer to any particular facts, reports, or tests that the defendant was attempting to suppress. And based on that, they're saying they're saying we just want to suppress the blood evidence. The state didn't comply with the OAC. And at no time did the attorney ever rectify or clarify that for the trial court and say, well, these are the specific issues that we're addressing. And so what happens is you have the state here prepared to go forward on the McNeely issue and on generally that they didn't comply with the OAC, but not what specific provisions.
And you are just now reaching into your 4 minutes rebuttal.
Okay. And then what I would like to say is that the state's burden in that case was only to prove by slight evidence, and that's based on this court's holding in. Well, I didn't list it in my notes, but I'm sorry, it is in my brief. This court has held that the state is only required to prove substantial compliance by slight evidence, and that it's a very small burden. In this case, the state put the phlebotomist on. She testified to how the blood was taken, to what was used. She didn't specifically identify the anticoagulant in the vial. She said that there was a substance in the vial, that she'd gotten the kit from the police, and that she followed all of these directions. And the state would submit that based on the defendant's failure to give a particularized statement of facts to support his motion, that was sufficient evidence. And I believe that the trial court erred in analyzing that and holding the state to the full substantial compliance with the Ohio Administrative Code. And I would reserve the rest of my remaining time. Thank you.
Good morning. May it please the court. My name is Michael Stepanek. My office represents Mr. McCall. I think that the case that Ms. Lanska was thinking about was State versus Slates, which this court decided that case is kind of important in this case for several different reasons. I think primarily I'd like to address the substantial compliance issue which was raised. It's not accurate that this court stated that in a substantial compliance analysis the state's burden is slight. That case does not say that. That case basically stands for the proposition that the state's burden is in proportion to the specificity that the the defendant raises in either his motion, or this court relied on a 12th district decision to say, or upon cross-examination. So the state wants to say that, well, you didn't put specific facts in the motion. Reading, if I could, from the motion to suppress that we filed, it says Mr. McCall's blood was not drawn with a sterile dry needle into a vacuum container with a solid anticoagulant. That's a fact that was raised. The state filed a motion in opposition to the motion to suppress, showing that there was a checklist, showing or attempting to show that it had been done. So if the state wasn't on notice, I'm wondering why they would then say, well, here, we complied with it, this is why, and then the morning of the hearing say, I didn't even know they were arguing that. I think that's a little intellectually dishonest. At the trial level, the morning of the hearing, the prosecutor that was handling it had actually advised the trial court, after saying that there was no specificity, said, I boiled it down, this is at page 8 of the transcript, I boiled it down to 3 main arguments that he has, and she goes on to give more than 3 arguments, that there is no probable cause, that because he was not validly arrested, he didn't give consent, there couldn't have been implied consent, and that the alcohol test, the instruments weren't working properly, that it wasn't within a 3-hour testing, the 3-hour testing limitation, and that the state would not be able to show substantial compliance with testing that blood, Your Honor. So I think that the state's allegation on appeal is completely inconsistent with what the prosecutor had represented to the court, that judge, there's 20 different assignments of error, or 20 different things that Mr. McCall is attempting to show. The only thing I can see are, among others, that the state would not be able to show substantial compliance with testing that blood. So I don't think that the record supports the state's argument, and I don't think that this case needs to be decided on a constitutional basis. I think that there's a lot of evidence from the trial court that the state did not meet its burden. I don't think it's general and slight because, again, citing slates, this court had said previously that it's general and slight in slates because that particular individual filed the motion to suppress, which was, I think this court noted, based on a blood test, but they included a urine test. So I think this court said, hey, you have a urine test being, complained of in your motion to suppress. This was a blood test. You're really not, I don't even know that this court thought that the trial attorney in that particular case had even looked at it. Further, in that case, the individual that prepared the actual blood testing kit was also the one who had tested the blood, and he was able to say, I create all of these blood testing kits myself. I know that they comply with OAC because I'm the one that deems compliance, and I'm further the one that tested it. This court noted in slates that there was virtually no cross-examination on the absence of substantial compliance. So in that case, the court said, and I think rightly, substantial compliance was never really attacked, either in the motion or on cross-examination, so the state doesn't have to bend over backwards to prove substantial compliance. But in this case, the phlebotomist had testified that she assumed there was anticoagulant. She said a couple of different times that she didn't see anything in the vial. The state never introduced evidence of anybody that had prepared these kits. Nobody knew where they came from. Every officer that testified said, we don't prepare these kits. So I think the court, based on not only that direct testimony, but also on common sense, said if she didn't see anything in the vial, anything, and she just says she assumed there's an anticoagulant, I don't think that that's substantial compliance. And that was not only put in the motion, that was also upon cross-examination. Further in the motion, said that the individual who analyzed Mr. McCall's blood test or test to determine whether he was under the influence did not possess a laboratory director's permit, nor were they under the direction of an individual who possessed that. We cite that as a fact, and we also cite the Administrative Code section. The individual who tested the blood testified that he had an assistant physical therapist license or degree. That's not a laboratory science, so therefore he could not have possessed a laboratory certificate. The state never provided any other information. They didn't call any other witness to show that that was different than what he had testified to. And again, Slates specifically says that cross-examination, I'll read directly from the Slate's opinion, it's quoting a 12th District Court of Appeals opinion, unless an accused, either through discovery or cross-examination at the hearing, points to facts to support the allegations that specific health regulations have been violated in some specific way, the burden on the state to show substantial compliance with those regulations remains general and slight. So if the state is attempting to say today that in all cases the burden is general and slight, that's not supported by the cases that they're citing. I think that the court was correct. The state never attempted to disprove or to prove substantial compliance based on what was testified to. So I think that this case on that alone should be upheld. I don't even think that the state assigns as error that there was substantial compliance. It just says that, well, we didn't really have much of a burden at all, which I think the case says exactly the opposite. Regarding Missouri versus McNeil, well, let me step back. The second assignment of error, that the court erred in determining that there was not consent. The police officers had testified that they had told Mr. McCall several times he had no choice, that he consistently resisted. Further, the phlebotomist, when she had testified, she says that he didn't want it done, and that kind of, I guess, supports what the police officers had testified to. On page 51 of the hearing, it says, Mr. McCall had no choice, correct? Yes. So it didn't matter to you whether he said yes or no, correct? Yes. And you had ignored his multiple no's to that point, correct? Yes.
If we agree, counsel, that McNeely really doesn't apply to this case because it did not address implied consent, does any of that really matter?
Well, a couple things about that. First, as I stated, I don't even know that the court needs to address McNeely because I think the substantial compliance has not been proven. Second of all, there's McNeely, I think does matter from the standpoint that McNeely doesn't change anything at all. And I think I cited this in the brief. 1966, the United States Supreme Court cited, Schmerber, and they said, listen, you absolutely need a warrant in order to pierce someone's skin, to go into their veins, to get evidence of a criminal case. Unless you have exigent circumstances. The only thing that McNeely did was say that an OVI case is not per se exigent circumstances. So from 1966 until today, Schmerber's been good law. McNeely basically just says Schmerber's still good law, and in any circumstance, you can't get a per se exigent circumstance because it's just an OVI. So it doesn't really change anything. In terms of the implied consent, I think implied consent, generally speaking, I think it's more on the civil range of things as opposed to looking for evidence to secure a criminal conviction. But interestingly, the United States Supreme Court, after McNeely, had vacated a Texas appellate court's determination that a forced blood draw was constitutional based on consent derived from an implied consent statute. That's Aviles versus Texas, 134 Supreme Court 902. And it vacated a Texas Supreme Court opinion. And on remand, the Texas Court of Appeals said that because Texas's mandatory blood draw statute does not consider the totality of the circumstances of each case, but creates a categorical or per se rule, the statute failed to establish a permissible exception to the warrant requirement. And I think that that's important because this court has said, or I'm sorry, the prosecutor has said that these officers were relying on slates, which said that the forced blood draw statute is constitutional. Well, not really. What the accusation was, or the challenge on appeal in slates was that it was facially unconstitutional, meaning there are no possible set of circumstances where the police can rely on this or that can be deemed constitutional. And what this court said is, well, yes, there is exigency. So this court, in upholding on a facial challenge to the constitutionality of the forced blood draw statute, said that, well, you cannot prove that in every single set of circumstances this is going to be unconstitutional because there's one set of circumstances, exigency, where it would, based on Schmerber. So I don't really think that McNeely changed anything in either this court or the United States Supreme Court case law. So I do think that the consent is very important because Ohio's implied consent law, like the implied consent law in Texas that the United States Supreme Court reversed or remanded back, said you can't have these categorical per se, no matter what, we're going to put a needle in your veins.
What would be an example of an exigency in an OVI case if it's not that if your sole purpose is you want to do it before the blood dissipates, the alcohol dissipates in the blood, what's an example of when it's going to be okay to draw that blood without a warrant?
Well, I think that's, as all the case law says, it's on a case-by-case basis. I suppose, if someone were to be, let's put it this way, let's say that somebody says, yes, I'm going to agree to a blood sample. And then they're hemming and hawing and they finally get to the hospital. The hospital is a great distance away. Let's say it's in the middle of nowhere, and then They get to the hospital 2.5 hours later, and then all of a sudden someone says, hey, you know what, I changed my mind, I'm not going to consent. Well, in that case, particularly because of the 3-hour limitation imposed by the revised code, or the administrative code, I think that there's only a half an hour to withdraw this blood. There is exigent circumstances. That's not the case here. In this case, the police said that we didn't even consider or care whether there were exigent circumstances. Officer Jama, he was one of the ones that was that had testified. He was being trained, actually, and he was one of the officers on the case. And he was asked, do you know why a warrant wasn't attempted to have been done? And he goes, I have no idea. He had no idea. They didn't even consider it. They just thought, hey, there's the statute. Let's just go with the statute. I guess it would be akin to the state creates a statute saying, you no longer need a warrant to enter someone's house. You no longer need probable cause. And the police say, hey, there's a statute. There's these cases that say it's, unconstitutional, but there's a statute now. I mean, the good faith reliance that the state tries to say, 1966 till now, Schmerber has never changed. So I think that it has to be a reasonably well-trained officer. I don't know, and I'm not going to pretend to know, maybe the state can give some guidance as to how the officers are trained, how they're given case law updates, why, whether there was any kind of training done to say, hey, this statute goes against what the United States Supreme Court said you needed in 1966, either a warrant or exigency to go into someone's veins. Why? Because the state the legislature got together and said, well, even though this case law exists, we're going to say you can do it anyway. We're not going to say you need exigency. We're not going to say you need a warrant.
So we're expecting the officers on the street to make that call where there is a statute that has been declared constitutional, and you're suggesting that they should say, well, yeah, but there's this U.S. Supreme Court case that says something else. They may not even be legally trained.
And that's what I'm wondering. I don't know. I think that good faith reliance and even probable cause determination, I guess supposes a reasonably well-trained officer. So I guess the point would be Slate says it's constitutional because the appellant in that case could not prove that there's no set of circumstances under which it would be constitutional. And the only one that this court recognized and stated in Slate's is exigency, citing Schmerber. So I guess, are the officers trained to say, hey, this is what Slate said? It said in an exigent circumstance situation, it would be constitutional?
Your example of exigency, when Judge Hensel asked you that, included consent. And you're saying, well, we're 3 hours away from where we can do a blood draw. But it's consent, so it doesn't really matter in that case because you have consent. You still haven't provided an example of exigency. And what would a police officer think of as exigent circumstances?
Where they couldn't possibly get a warrant. They couldn't possibly. There's cases where someone will get arrested at 2-something in the morning. There's no neutral and detached magistrate even awake at that time. So how do they go about getting a prosecutor, getting a warrant? This happened early in the morning. There was no attempt to try to call anybody. No attempt to try to get a warrant. So I suppose the state, the police officers all testified, we didn't even make an attempt. Mr. McCall was arrested, taken from his car, and that was it. So there was no claim of exigency in this case.
Well, but wasn't it the fact that it wasn't his first OBI?
Isn't that
why they relied upon the statute to do the blood draw, because it wasn't his first one, it was his 6th and 20?
Yeah, that's why they did it. Yeah, they thought that they were able to because of this statute, which again, the statute goes against case law that's been around since 1966.
And counsel, you've reached the end of your time.
Thank you very much.
You have just about 2.5 minutes.
Thank you, Your Honor. I just wanted to, since the issue of an example has been brought up twice for exigency, although I don't think it really matters in this case because we weren't dealing with a situation where the state should have had to prove exigent circumstances. But an example would be a defendant who's unavailable to give consent because of his condition, say from injuries suffered in the accident, and that the police officer is told he's going to be going into surgery, he's going to be there for 5 or 6 hours, this is a long procedure, and you know, whatever you need, you better get now. You know, that's an example of where the state may argue that there's some exigent circumstance, not necessarily that he has to be taken several hours away to a hospital, and I would question who's gonna be available to do the blood draw if you have to go that far to get to a hospital. Usually that's where the police take people for, you know, a blood sample in OVI cases. But an example would be where the defendant has sustained such serious injuries that the police officer is being told he's not going to be available to you by the time you get a warrant and get back here. We're taking him into surgery now, and you better get what you need now. You know, that's an example I think that the state would have evidence to support that there are exigent circumstances. In this case, I also want to speak to the issue of what counsel has said about the officer, a reasonably well-trained officer. I don't know of any training program where an officer is taught if there's a statute, then you need to go beyond that. If the statute says you can do A, you need to go beyond that and analyze what the Supreme Court has said from 1967 to present and decide, independent of that statute, whether you think what you're doing is violating a defendant's Fourth Amendment right. Officers are simply not trained to think like that. That's what defense attorneys and prosecutors and judges are asked to address after the fact. Because an officer says, I have a statute that says I can do A, I'm going to do A, and that's what he does. That's how a reasonably well-trained officer is trained, to follow the law. And that's what the officers in this case were doing. I don't think that there was any violation of the Fourth Amendment right, and I think that when you look at Slates, if I recall, the court did not choose to apply McNeely retroactively. I think it was Slates, I'm not certain it's cited in my brief. This court did not choose to apply McNeely retroactively because there's that good faith exception to the warrant requirement. And that doesn't address whether a case is or is not retroactive when something is pending on appeal. That addresses the knowledge that the officer has about what the law is at the time he takes a particular action, which is well before you get to an issue of whether we're going to, as lawyers, apply a case retroactively to something that was pending on appeal after it's decided. That's not really what the issue is. The good faith exception is what the issue is here. Thank you, Your Honors.
Thank you.
And the state would ask that the court overturn the trial court's decision to suppress the evidence in this case.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.